The Civil War did not radically alter the U.S. Constitution or the scope of federal powers. Neither did the Reconstruction Amendments or the Progressive Era Amendments. It wasn't until the years following the 1929 stock market crash that the Supreme Court began rewriting the Constitution. Constitutional scholar Rob Natelson explains in this week's IITV podcast interview. I'm Ben Murray, director of the Fiscal Policy Center here at Independence Institute, and I'm back on with Rob Natelson. Rob is the director of our Constitutional Studies Center here at the Institute, and he's also a senior fellow in constitutional jurisprudence. He has been cited by the Supreme Court over 36 times, and today we're going to be back on with him talking about his essay series on the Supreme Court entitled How the Supreme Court Rewrote the Constitution. Rob, thanks for joining me.
Great to be back with you.
So, Rob, during our previous discussion last week, you said, and I'm going to quote you, you said the federal government was recognizably the same institution in 1925 as it had been in 1790. You said most of the founders would have been very comfortable with the scope of the federal powers at the time, and you said it was recognizably the same as it had been 135 years prior, despite major changes to the country like an industrial revolution, a civil war, a world war. But after the 1929 market crash, and then you had the Great Depression, that all began to change. So set the stage for us here. Who was the president at that time, and how did the federal government respond to the crisis?
The president was Herbert Hoover. And there's a myth out there that Herbert Hoover was an uncompromising conservative who did nothing to deal with the Depression. In fact, Herbert Hoover was a progressive Republican. There were many progressive Republicans in those days, including, as we'll see, the Chief Justice of the Supreme Court. And he undertook a program of federal activism, including a higher tariff designed to protect American manufacturers, and a great deal of federal spending designed to prime the pump of the economy. However, ultimately that proved to be inadequate, or some people would argue that he actually made things worse through this federal activism, and he was defeated for re-election in 1932 by Franklin Roosevelt.
You're right. I think about Hoover, right? That's certainly an impression a lot of people have, is that he was radically different from Roosevelt. You're saying they're pretty much the same. But then that raises a different question. If they were very much the same in their policies, how did Roosevelt beat Hoover?
Well, Roosevelt didn't campaign for doing the kind of thing that Hoover did, but more. He campaigned, in fact, in favor of cutting spending, retrenching the federal government by about 29%. In spending. So he was elected as a fiscal conservative, but as was common with Franklin Roosevelt, he actually wound up doing something very different. And he out-Hoovered Hoover and spent a lot more money.
Roosevelt and fiscal conservative just sound odd together.
Right. He spent a great deal of money. And the conventional wisdom was that, again, that he helped get us out of the Depression that way. But the actual historical record is different. As some writers have pointed out, the Depression became the Great Depression under his watch. Many of the things he did probably made things worse, and that became apparent by 1937, where a very halting recovery became another descent into depression again. We really did not get out of our economic doldrums until after World War II, when government controls over the economy were lifted.
And you did have, during that Roosevelt era, the Depression part of his term, you had a lot of federal intervention, federal government intervention in the economy to try to combat that depression or what started out as a recession.
And they didn't. The New Dealers really didn't know what they were doing.
But
they would experiment with different things. So, for example, they took the currency off the gold standard on the theory that would cause inflation, and that inflation would stimulate the economy. They established codes whereby minimum prices for goods were established, again on the theory that this would somehow help the economy. And then they spent a great deal of money on this pump priming. None of it seemed to work. And again, arguably it made things worse because it created the kind of uncertainty that makes people unwilling to invest.
Well, and we can say that in hindsight, right?
Yes.
But, at the time you had Keynesian economics that was very popular. It was kind of a fad at the time. You had a lot of ideas coming from Prussia and Europe that were very popular about how to manage the economy.
Not just Prussia. One of the heroes of many of the New Dealers was Mussolini.
Mm-hmm.
In fact, when they established the National Industrial Recovery Act, which the Supreme Court ultimately overturned by unanimous vote, that was based on an Italian fascist model. Fascism at that point, and this is pre-Hitler, or in Hitler's very early days, fascism was seen as the vision of the
future. Very modern, very trendy.
Very modern, right.
So not with the benefit of hindsight, but actually at that time, folks who were maybe more strict constructionists, let's say, might have been critical of some of the things he was doing. But could you not argue, if you were actually living in that time, an unprecedented economic depression was upon us, that these were extraordinary times that called for extraordinary measures, and reasonable minds could disagree about whether the federal government had the power to do everything Roosevelt did, but couldn't you argue that, like I said, extreme times call for extreme measures?
You have a constitution, partly because it is a protection against trendy thinking and against big mistakes. So in the past, what had happened was that we had many depressions and recessions, but the federal government, because of constitutional limits, was limited in how much mischief it could do. The trendy feeling in the 1930s was that these constitutional restraints were out of date, that they really should be superseded, and ultimately that trendy feeling turned out to be inaccurate. If you're going to change the Constitution, it should be as a result of the overwhelming lessons of experience. And what the New Dealers wanted to do is they wanted to change the constitutional rules based upon their guesses rather than the lessons of experience.
But this wasn't the first time that an executive came in and during a crisis did something or multiple somethings that were arguably an overstep of their constitutional authority. I mean, you had Lincoln in the Civil War. A lot of our libertarian audience is very critical of Lincoln and could point to some things that they don't like that he did. Suspending habeas corpus is one of the classic examples. But you also had Woodrow Wilson. So my question is, what was different this time?
Well, in the case of Wilson, and his action in suspending habeas corpus in areas outside the war theater ultimately was struck down by the U.S. Supreme Court. In the case of Wilson, his adventuresome experimentation with a big federal government during World War I was reversed, or largely reversed, by the election of 1920. So those were some things that were different. But the changes that occurred during the New Deal were due largely to the prevailing zeitgeist or spirit of the times, but also due to changes in the Supreme Court that occurred, especially after 1937.
But unlike the Supreme Court, after Lincoln suspended the habeas corpus and they overturned that, the Supreme Court here didn't necessarily do their job. I mean,
right.
not to put it too bluntly, but tell me about the makeup of the Supreme Court leading into this seismic shift in how the Supreme Court interpreted, let's say, the Constitution.
Today, among many quarters, the idea of originalism, of applying the Constitution as it was understood to the ratifiers, is controversial. But before the time of the New Deal, originalism was a standard orthodoxy for how you apply the Constitution as you apply any other legal document. I mean, it's true that you would change the application of the rules somewhat, depending upon whether the legal document you were interpreting were a contract or a constitution, but still the vision of the framers, or more precisely the vision of those who adopted the document, was the standard rule. In the 1930s, that already had begun to break down. So you had a Chief Justice, Charles Evans Hughes, who was a progressive Republican, who was skeptical about the idea of originalism. And you had several other people on the court that were skeptical. So at the time Franklin Roosevelt came into power in 1933, the court was already sort of flirting with the direction of a living constitution, but things really changed, as I mentioned, after 37.
Well, and this is interesting to me as you talk about these progressive justices. Many of them, including Charles Evans Hughes, were appointed by Republicans. So it wasn't necessarily the same political lines, left and right, progressive versus conservative. I mean, you had progressives that were appointed by Republicans. You had conservatives that were appointed by Democrats. Talk to me about that, because that seems kind of odd.
Well, it was understood previous to the New Deal that although people might have different political views, conservative or progressive, and even somewhat different political philosophies, that everybody was bound by the Constitution as it was originally understood. And so you're right. I mean, you had people like Benjamin Cardozo being appointed by a Republican president, even though he's remembered in retrospect as a progressive. The notion of simply shattering the constitutional consensus was in the future, still in the early 1930s, but things were beginning to change. I mentioned in my article a good example, a case which did not involve the federal government, but involved state governments, the Blaisdell case, in which Chief Justice Charles Evans Hughes lays out the progressive creed in upholding a state law that appears to be a clear violation of the Constitution. That progressive creed was to become the creed of the majority of the Supreme Court in future years.
I'm glad you brought that up, and I want to come back to it because I want to read an excerpt from that case.
Yeah.
But before we get there, tell me about the makeup of the court. Who was on the court? We talked about how some were progressives versus conservatives, and let's define terms. I mean, what did it mean to be a liberal or progressive versus a conservative then compared to today?
Well, first, to be a conservative in those days was essentially to be a conservative activist. That is, somebody who was willing to bend the Constitution to serve conservative political views. And there were three people on the court that fit that category. We have not had a conservative activist on the court since the last one of those, James McReynolds, retired in 1941.
And this is about 1934.
1934. So when you hear the mainstream media today talking about us having a 6-3 conservative majority on the Supreme Court, we don't have anybody like those conservative activists as they were on the court in the 1930s. And then there were three progressives who were on the court, Cardozo, Stone, and Brandeis. They tended to be politically liberal. They do tend to bend the Constitution a little bit more than I would, for example. But again, as liberals or progressives, they were nothing like, let's say, a Justice Sotomayor today, who is actually willing to, in my view, distort the Constitution for left-wing ends. And then you had three justices who were essentially in the middle. There was George Sutherland, who came from a progressive background and who had kind of a mixed record. Owen Roberts, who tended to flip back and forth. And then the Chief Justice, who was a moderate progressive, but who tried to strike a balance in his career, which lasted until 1941. He wanted to try to find some way to reconcile at least some of the New Deal with the Constitution.
So this is 1934, and you talk about in your essay that by the end of World War II, this makeup had radically changed to where almost the entire court were activist progressives. And I love this quote that you gave. We're coming back now to that quote that you mentioned earlier from Chief Justice Hughes, because I think that it so perfectly establishes the kind of thinking that you began to see in the court as it became more and more actively progressive. And here's what he says in that decision. He says, "There's been a growing appreciation of public needs and of the necessity of finding ground for a rational compromise between individual rights and public welfare. The pressure of a constantly increasing density of population, the interrelation of the activities of our people, and the complexity of our economic interests have inevitably led to an increased use of the organization of society in order to protect the very basis of individual opportunity, where in the earlier days it was thought that only the concerns of individuals or of classes were involved, and that those of the state itself were touched only remotely, it has later been found that the fundamental interests of the state are directly affected. And then he goes on and he talks about how we need to have a more expanded understanding of the Constitution, almost like a living Constitution.
Yeah.
Talk about what does Hughes mean by all this? What is he saying?
Let me first make it clear. Charles Evans Hughes didn't take this philosophy and carry it to its ultimate extreme. As Chief Justice, Charles Evans Hughes tried to mediate between the Constitution and the New Deal, and eventually he lost. But that statement that he made is a statement of the progressive philosophy. Number one, the belief that it's a much more complicated society than it used to be, and that human affairs are much more integrated than they used to be. And maybe the founders didn't understand that, so they focused on individual rights. But today we need to temper individual rights with social welfare. So that's part of what he's saying. He's saying also that we shouldn't really be applying the Constitution in the way that the founders understood it. We need to we need to reinterpret it in various ways. So that basically is a statement of the progressive creed. Now, what he is saying, I should say, is inaccurate. The founders thoroughly understood that people in society are interdependent, that one person's actions affect another. But they put a primacy on rights. They put a primacy on individual rights, even when at first blush it might seem to be contradictory to common welfare. And the notion about not interpreting the Constitution according to the founders' understanding was a progressive doctrine, but it was very different from what judges had previously believed.
I want to read another part of that same decision
Sure.
that you put in your essay here, because I think it really gets at what you're saying. He says, if by the statement that what the Constitution meant at the time of its adoption, it means today, it is intended to say that the great clauses of the Constitution must be confined to the interpretation which the framers, with the conditions and outlook of their time, would have placed upon them, the statement carries its own refutation. It was to guard against such a narrow conception that Chief Justice Marshall uttered the memorable warning, quote, "We must never forget that it is a constitution we are expounding." Is Hughes interpreting Marshall correctly here? Is this what he meant?
He's misinterpreting Marshall. What Marshall was saying in that language from McCulloch versus Maryland, 1819, was that when you search for the intention or the understanding of the founders of a constitution, you have to apply the rules a little differently than when you search for the intention or understanding of the people who made a contract. He's not saying that you should disregard the intention of the founders or the understanding of the founders. He's saying that the nature of a constitution is such that the rules of evidence are a little bit different. What Hughes is claiming that Marshall is saying is we have to disregard the understanding of the founders. That's not what Marshall is saying at all. And unfortunately, in future years, liberal jurists have continued to misinterpret Marshall in that way. His other part of his statement is to say, if by following the original Constitution and saying what it means today, that it meant that it means today, it carries its own refutation, that's nonsense. It doesn't carry its own refutation at all. If you're going to argue that the Constitution shouldn't be applied the way the founders would have applied it, you've got to come up with some good evidence for that, not simply say it carries its own refutation. Unfortunately, that's the kind of gibberish that underlays a lot of living Constitution theory.
It seems to me this is really the crux of it. This is the crux of this pivot, this change, is you went from 135 years of mostly having a majority Supreme Court that had let's call it the traditional understanding of how to interpret the Constitution, the proper understanding of Marshall's statement there, right? That it's the Supreme Court's job to interpret the Constitution, but interpret it as the founders would have understood it.
Yes.
When they wrote it. And then you have this shift here, and you say in Hughes it was moderate. He was he had this view, but he was more moderate in how he would have applied it. But as we move forward through the 30s and into the 40s, during the Roosevelt administration, as Roosevelt appointed more and more judges, the court became more and more stacked in favor of this progressive view that said, we don't need to interpret the Constitution through the lens of how the founders would have understood it when they wrote it. But instead, it's a living Constitution.
Yeah, and the contrast between them and these later judges and Chief Justice Hughes can be explained in part in this way. Chief Justice Hughes was one of the most respected men in America, and he had been a Supreme Court justice several years before he was appointed to Chief Justice. He had been Associate Justice of the United States Supreme Court, and then resigned in order to run for president as the Republican nominee in 1916, and then in 1930 he was reappointed by Hoover to the court. Chief Justice Hughes, like many if not most of his predecessors, had had extensive judicial experience. And whatever might be their theories about progressive jurisprudence, they also were acculturated into applying precedent, into respecting the wording of the document, respecting the views of the founders, and so forth. The judges that President Roosevelt appointed to the court, by contrast, almost all were without significant judicial experience. They were politicians. And because they were politicians, they did not have the kind of internal restraints that Chief Justice Hughes had, even though philosophically he may have agreed with much of what their views were.
So now we find ourselves in a time in American history where we're seeing some of the greatest crises, the Depression followed by World War II. And that's coinciding with a progressive executive who sees an expansive role of the executive branch in the federal government beyond what the founders intended. And you have increasingly an activist progressive Supreme Court that is political and is rubber stamping what the Roosevelt administration is doing.
Yes.
And your topic of this essay series is how the Supreme Court rewrote the Constitution. So I think we've set the stage here. I mean, this is the setup we have going into that time period where you saw, as you argue in your essays, the Supreme Court truly rewrite the Constitution by rubber stamping what the Roosevelt administration was doing rather than reining him in. And what I want to do is have you back on and talk about the specific policies and the specific decisions, the rulings the Supreme Court made over that next decade or so that effectively rewrote the Constitution. So if you don't mind coming on maybe next week, we can do that. But in the meantime, where can folks go to read your work? Maybe they can get ahead of this and read your whole essay series.
All of my writings ultimately wind up on independenceinstitute.org in the Constitution Studies page. So you go to independenceinstitute.org, you'll see a tab for issues, go to Constitution, and they're there. And if you enter search words like Hughes or rewrote, that will bring you to the entire series on how the Supreme Court rewrote the Constitution.
Rob, thanks so much, and I look forward to continuing our discussion.
Thank you.